For those who are joining us, we will give people a few moments to all get into the room and then get started. Okay, so it looks like the number of people entering the room has stopped for a moment. So we will go ahead and get started. Um, Depending on where you're joining us from, good morning, good afternoon, good evening, or good very late evening, or very, very early morning. Thank you so much for joining today's webinar on Overthrowing the Future, the Constitutional Court of Thailand. My name is Tyrell Haberkorn, and I'm a faculty member in Southeast Asian Studies at the University of Wisconsin-Madison. This webinar is being sponsored by the Justice in Southeast Asia Lab, or the JC Lab, which is generously funded by the Henry Loos Foundation, and the Article 112 Project, which is generously funded by the Anonymous Fund at UW-Madison. Founded in 2021, the JC Lab fosters intensive exchange among faculty, graduate students, and practitioners, as well as public-facing events such as this one that aim to foster discussion among these various groups. The JC Lab reflects both the recognition that a growing number of MAs and PhDs in Southeast Asian studies are choosing to pursue professional careers outside the university, but more importantly, that there is a need for academic work and universities to be directly responsive to ongoing social justice crises. Founded in 2023, the Article 112 Project is concerned with its namesake, Article 112 of the Thai Criminal Code, which defines the crime and stipulates the punishment for lèse-majesty. Quote, whoever defames, insults, or threatens the king, queen, heir apparent, or regent shall be punished with imprisonment of 3 to 15 years. Thailand has been a constitutional monarchy since the 24th of June, 1932, but the relationship of the monarchy to democracy has remained unclear, not least evidenced by the existence and use of this law. Over the past 20 years, the use and abuse of the law to suppress peaceful expression and silence discussion of crucial social and political questions in the Thai polity has risen at an alarming rate, with sentences reaching many decades. Despite the urgency of this rise and the analytic questions it necessarily raises, scholarship has remained relatively spare, and restriction of freedom of expression in Thailand remains relatively unknown outside the country. The Article 112 Project responds to this by expanding scholarship and public engagement through teaching, translation of key documents, and collaboration with relevant US, Thai, and international scholars and NGOs through events such as this one. So to turn to today's event, many of you will be aware that the use of Article 112 to criminalize peaceful dissent has been on the rise since the 2006 coup, nearly 20 years, and that the number of cases has increased tremendously since the youth-led democracy movement in late 2020, with Thai Lawyers for Human Rights reporting that there are at least 271 people being prosecuted in 302 cases. Parallel to the criminal prosecutions, similar constriction of rights and freedoms has occurred at the hands of the Constitutional Court. This has involved using a measure of the Constitution, Article 49, originally aimed to prevent against coups, that legislates against the excessive exercise of rights and freedoms to overthrow rule by democracy with the king as head of state. When a complaint under this article is brought to the court, they then examine it and determine whether or not those named in the complaint are engaged in a process of using their rights and freedoms to be engaged in overthrow. In late 2021, the Constitutional Court ruled that peaceful speeches made by youth activists questioning the place of the monarchy in Thai society and calling for reform was equivalent to overthrow of rule. Most recently, and the impetus for today's event, on the 31st of January, the court ruled that the proposal by the Move Forward Party to amend Article 112 to, among other things, reduce the punishment constituted overthrow of rule by democracy with the king as head of state. This proposed law was never examined in Parliament, let alone voted on. Let me repeat this: a proposal to amend a law using parliamentary process by an elected political party has been ruled to constitute overthrow of rule. In late February, the full ruling and the individual opinions of the 9 constitutional courts were released in Thai. We're currently working on an English translation of the full ruling, and it should be available on our website, which I'll put in the chat by the end of the week. If you are confused, how could speeches or the proposal of a law amount to overthrow of rule by democracy with the king as head of state? Then you're beginning to understand what is at stake. It is tempting to simply view the Constitutional Court's actions as another level of the repressive work of the judiciary, which it is, but it's also the redefinition of fundamental aspects of public life, the duties of citizens, and the meaning of law. This all demands careful examination. Today's speakers, whom we are so lucky to have with us, will begin this examination. So to let everyone know how we'll proceed, each of the speakers will speak for approximately 10 to 15 minutes, and then we'll have time for discussion. A note on process: we'll use the Q&A box for questions, and you may put your questions there whenever you have them. So without any further delay, let me begin by handing the screen to Akarachai Chaimaneekarakate, the International Advocacy Lead for Thai Lawyers for Human Rights. Thank you so much.
Hi, everyone. Can you hear me good? Can you hear me well? Perfect. Can you see the screen I'm sharing?
Yes.
Perfect. Hi, everyone. So I just want to take time to speak about the Constitutional Court's ruling, and thank you so much, Ajahn Tyrell, for inviting me to speak on this amazing panel. So the topic of my intervention, I just want to talk about Thailand's Constitutional Court and the constitutionalization of the less just law, and what I mean by that. I will get into that in a bit. Before that, I just want to very quickly make an observation that as we're speaking today, we still think that Thailand is still in a human rights crisis. And why do I say that? And if you just look at these figures, and these are just figures based on the number of clients and cases that our organization represents in the past decade, you will see that between 2014 and 2020, the number of cases we usually represent per year is around 30, 40 cases. Then came the mass pro-democracy movement in 2020, led primarily by young people. We are talking middle schoolers, high schoolers, university students. That number increased to more than 200. And then by the end of 2021, more than 800 something. So that's a 20-fold increase in the number of cases in the span of 1 to 2 years. So that's an extraordinary figure. On top of that, between January 2021 to now, there's been an increase in more than 1,000 cases, or more than 600%. As we're speaking, almost 2,000 people have already been charged under various repressive laws. We're talking about the less just law, we're talking about the emergency decree, we're talking about the Public Assembly Act, or other laws you can think of used to criminalize peaceful dissent. So that's the state we are in, and based on these numbers, we make the observation that we are still in a crisis of freedom of expression and freedom of peaceful assembly. And if we look at the use of the less just law to prosecute opposing views in the past few years, you will realize that it's been intensified quite drastically. In January 2021, the number of cases was at 42. Now we have more than 300 cases already. So that's an increase of almost 600%. And what's interesting to note is that the indictment rate for this law has remained at 100%, which means every single case sent from the police to the prosecution, there has yet to be a case where the prosecution refuses to indict the person charged, the people charged with lèse majesté. That's an extraordinary observation in the sense that it says a lot about the way in which discretion has been exercised by the prosecution. And we are talking about a prominent human rights lawyer, Mr. Arnold Nampa, who called for monarchy reforms and as a result of that has been sentenced to 8 years in prison already and still faces 12 more lèse majesté cases for which the court has not issued verdicts. We are talking about a record-breaking sentence against an activist from northern Thailand who was sentenced to 50 years in jail, 50 years in prison for posting clips, sharing clips on his private Facebook account. Clips like, for example, from John Oliver's Last Week Tonight show, clips from the American sitcom animated series, American Dad, clips from the BBC documentary Soul of a Nation. For that, 50 years in prison. We're talking about a person who was sentenced to 3 years in prison for mocking the Queen by wearing a Thai traditional costume. And we are talking about activists being prosecuted simply for conducting public opinion polls in central Bangkok, asking passers-by whether they think that royal motorcades cause inconvenience to the public. Simply for conducting public opinion polls, they are being prosecuted under the lèse majesté law, the penalty for which is 3 to 15 years of imprisonment. So that's the state we are in right now. So with that political legal backdrop, that backdrop of political prosecution in mind, I want to move on to the next part of my intervention about the role of the Constitutional Court in the use of the lèse majesté law to prosecute opposing views. And some key constitutional provisions I want everyone to have in mind before I get into specific rulings. So obviously, we are talking about the constitutional right to freedom of expression under Section 34. And the two other really interesting provisions, which will be key to our discussion here, is Section 6, or Article 6 of the Constitution, which states that the king shall be enthroned in a position of revered worship or sacredness and shall not be violated. No person shall expose the king to any sort of accusation or action. And as I will note later, Article 112 of the Criminal Code has been very much linked and tied to this constitutional provision in a way, imbuing constitution-like characteristics to a criminal code provision. And the final provision would be Section 49, that no person shall exercise the rights or liberties to overthrow the democratic form of government with the king as head of state. So with these in mind, let's look at the first ruling I want to talk about, the 2012 ruling. The facts in this case are quite simple. The defendant was an editor of a magazine which published articles with allegedly lèse majesté content. The defendant himself was not the author of these articles. The Constitutional Court held in that case that Article 112 is compatible with the constitutional right to freedom of expression. In fact, and this is interesting, the Constitutional Court held that Article 112 is required in order for the Constitution to have practical effect. Why? Because as I said before, under Article 6 of the Constitution, the king is sacred and inviolable. The court said, in order for the king to be truly sacred and to be truly inviolable, people must not be allowed to criticize the king. Because Section 112 or Article 112 prohibits people from criticizing or insulting the king, Article 112 in that sense is giving real practical effect to Article 6 of the Constitution, making the king truly inviolable and the king truly sacred. So this is the first Constitutional Court's ruling that links Article 112 with a constitutional provision on the king's sacredness and the king's inviolability. Then we have the, I think I may have written the year wrongly. But yeah, we have another ruling where the defendants in this ruling were activists who advocated for the revocation of Section 6 about the sacredness and inviolability of the king, as well as, and they called for the abolition of Section 112 of the Criminal Code as well. And the Constitutional Court again held that the defendants' demands were tantamount to treason, that these demands constituted overthrow of rule. And this is another ruling where the court again tied Section 112 to Section 6 of the Constitution, saying that Section 112 of the Criminal Code is required for Section 6 of the Constitution to have real practical effect. And then came the most recent Constitutional Court's ruling on the Move Forward Party's proposal to amend the Last-Majestic Law. And the question in this case was simple: whether the party's proposal to amend Section 112 during the campaign period is tantamount to treason. And the Constitutional Court held that yes, by proposing to amend Section 112 of the Criminal Code, Move Forward Party was in effect intending to overthrow the democratic form of government with the king as a head of state. I just want to go into details a little bit more when it comes to this case as to how the court arrived at this particular legal conclusion. So Move Forward Party proposed to remove Section 112 from the National Security Chapter of the Criminal Code. And the court said by trying to do that, Move Forward Party was trying to separate the monarchy from the nation. And by trying to separate the monarchy from the nation, that is to say, by making lèse-majesté no longer a national security offense, that in itself is a danger to national security. Move Forward Party tried to introduce the defense of truth and the good faith criticism exception to the lèse-majesté offense. The Constitutional Court said that in doing that, the party was trying to put monarchy on trial, because every time people raise the defense of truth or the good faith criticism exception, when they are tried in court under the lèse-majesté law, the monarchy would effectively be put on trial as well, as people try to prove the veracity of their statements about the monarchy. That, the court said, would adversely affect the king's sacredness and inviolability. Also, the party tried to limit who can file complaints under Section 112 to the royal household. Right now, as a law, the current status of the law is that anyone can walk to the police station and file lèse-majesté complaints against other people. By trying to limit this power to the royal household only, the court said that the party was trying to put the monarchy in direct conflict with the people, because if the royal household were to be the one making complaints against the people, then that would in itself be putting the monarchy in direct conflict with the people. The court also found that the party possessed the intention to overthrow constitutional monarchy. How did the court find this intention? Despite the fact that the party was using the legislative means to amend the law, the court was saying that by using a parliamentary process to amend the law or try to amend the law, the party was in fact trying to hide its true intention to overthrow the constitutional monarchy. In fact, the fact that some MPs, members of parliament for Move Forward Party, serve as bail bondsmen for Section 112 defendants, that, the court said, is evidence of the party's intention to overthrow constitutional monarchy. And as a result of this ruling, there are two ramifications that might happen soon. First is risk of party dissolution. In fact, this is something that is already, the process has already been started. And the second ramification is the risk of lifetime ban from holding political office for 44 Move Forward Party MPs who signed on to the bill to amend Section 112. Before ending my intervention, I realize it's almost 15 minutes, I just want to quickly speak about the implication of this ruling. And as I alluded to before, as a result of these rulings, Article 112 has effectively attained a constitution-like characteristic, given that it is now linked to Section 6 of the Constitution about the sacredness and inviolability of the king. In fact, it's interesting to note that it's unclear as to how difficult it is to amend the lèse-majesté law, or whether it is possible to begin with to amend the lèse-majesté law. In the most recent Constitutional Court ruling, the court did say that it is possible to amend the lèse-majesté law through a legitimate legislative process, but it begs a question as to how was the process used by the party not legitimate to begin with. The court said that the purpose of Section 6 of the Constitution is to, in a way, give effect to the king can do no wrong principle. Many people argue this is a true purpose of Section 6 of the Constitution. But I just want to note very quickly that the way in which this principle has been applied in the UK, in Spain, in Belgium, all constitutional monarchies which have similar provisions to Thailand's Section 6 of the Constitution, the courts in those countries do not interpret the principle in the same manner as Thailand's Constitutional Court. And if I have time during Q&A, I'm more than happy to go into more details, but I just want to end my intervention here about the Constitutional Court ruling so far and its role in the use of lèse-majesté law in Thailand.
Thank you so much. Let me now hand the screen to Eugénie Mérieau, who is Associate Professor of Public Law at the Paris 1 Panthéon-Sorbonne University. Thanks so much.
Hi, everyone. Thank you very much for the invitation. Thank you very much for putting this together. Some of the points I will be talking about resonate very much with what Akarachai said just earlier, but my perspective is somewhat different. I'm not going to here adopt a human rights perspective, not even a normative perspective at all. I am going to speak from a legal anthropology or critical comparative law perspective. So let me start with a few legal definitions. As you mentioned, the key point here, the key term is democracy with the king as head of state. What is democracy with the king as head of state? Is there a legal definition attached to it, and what's the story behind it? So if we look at the Constitution, this is the term that is scattered throughout the entire text. It defines Thailand, which is Article 2. We also have the very important Article 49, which we just mentioned, which is the key article through which the Constitutional Court locks in public discourse, public speech, and the entire public space in Thailand. And also Article 255, which is what we call the Eternity Clause, which gives to the Constitutional Court the role to prevent any amendments to the DKHS. Therefore, the entire system of democracy with the king as head of state is locked, in that if tomorrow the parliament wants to revise the constitution to get rid of democracy with the king as head of state, to be able to actually venture into the reform of lèse-majesté, right, which would be the right route to go based on the Constitutional Court ruling, then it cannot do it because there is this Article 255. So this system is locked. So we first have Article 2, Thailand adopts a democratic regime of government with the king as head of state, Section 49 and Section 255. So altogether, these three articles define the constitutional identity of Thailand according to the authoritative definitions which are given by the court. And this is just a realist interpretation of the law, that to say that what the courts say the law is the law. So the Thai Constitutional Court, as was mentioned earlier, has said that the democratic regime of government with the king as head of state is Thailand's constitutional definition. Therefore, it cannot be amended, and every attempt to change that must be stopped. So this doctrine comes from Germany. It was built by Karl Löwenstein, who is a German lawyer who fled Nazi Germany, and who had that idea that democracy has the potential to overthrow itself. That's the Nazi example. Therefore, we needed to lock in the values of the constitutional order within the constitution and to give the constitutional court the powers and the means to prevent the overthrow of the democratic order from the inside. So all these three sections are actually copied and pasted from the German Constitution of 1949, which gives the Constitutional Court the ability to dissolve political parties, the ability to order an entity to stop using liberties to destroy the democratic order. So that's a very important aspect. So that's one part of it. And of course, the second part is the king as head of state. So this part is the indigenization of the German principle of militant democracy. And democracy has been progressively defined by the Constitutional Court and also by the doctrinal work of a few lawyers as encapsulating Buddhist ideas, Buddhist notions of kingship. So when we look at democracy with the king as head of state, the Thai lawyers have since the very early 20th century and moreover since the 60s and 90s defined this as encapsulating Buddhist notions of kingship, which give the king a position that is above the law. So that's how that work has been done. And in 2012, as was mentioned, the Constitutional Court ruled that lèse-majesté was precisely what was giving to Thai democracy with the king as head of state its indigenous, very Thai character, which is to be based not only on militant democracy like we do have it in Germany, but also in Buddhist notions of kingship and this idea that the king has to be in a position of revered worship. Now, of course, the Thai Constitutional Court has also used Thai democracy with the king as head of state to give broader contours to that constitutional identity that the Constitutional Court must defend. For instance, it has ruled that it is part of Thai constitutional identity to have an appointed Senate. You remember in 2013, when the political party at that time, it was Pheu Thai, wanted to revise the constitution to have a fully elected Senate, the Constitutional Court intervened and ruled that this amounted to, that was a threat to the democracy with the king as head of state. Right? And we have another very interesting ruling that is not very well known, where the court basically makes the same argument in an embryo form in 2007, ruling that military coups are in fact part of democracy with the king as head of state when it comes to defending the monarchy. So the Thai Constitutional Court has built that doctrine with the help of lawyers. Right, of course, we can be very critical of that entire enterprise of definition. We can look at it, and that's what I've done. In my previous work, we can look at it as a sort of bricolage, basically an arbitrary construction, legal construction for political purposes. Of course, the political purpose is to maintain the status quo with the king and the military, which depends on the king, as for symbolic power, as being very much locking in the entire political and constitutional order, space, discourse in Thailand. So I just put here a few quotes that I really like from anthropologists talking about how bricolage works. And bricolage is that manner of assembling things from here and there. So things from Germany, things from ancient Buddhist doctrines, and then putting it into some sort of coherent discourse, which will become, because it's law, a performative discourse, and which will give to democracy with the king as head of state its peculiar, but nevertheless authoritative definition. And this works in Thailand like it works everywhere else. So I use another quote to exemplify this, which is by Bourdieu. When the Constitutional Court says this is what democracy with the king as head of state is, it produces that reality. And because law is that power, as that symbolic power to name, to create the things as it names them. So whenever the Thai Constitutional Court says in 2012, well, lèse-majesté is part of Thai constitutional identity, and democracy with the king as head of state means there is lèse-majesté there, then it creates that actual reality. And that's why if we look at the ruling that we had to look at for today, it is very much coherent with the past rulings of the Thai Constitutional Court, which says that lèse-majesté is part of the very definition of Thai constitutional identity. Once again, we can have a very critical discussion of that discourse put forth by Thai Constitutional Court that lèse-majesté is 100% indigenous and the identity of Thailand. If we do the genealogy of Article 112, there's nothing less indigenous than Article 112. It's a copy and paste from the Prussian late 19th century penal code. It was then amended several times, and that's how it has become what it has become today. So it has a very also non-indigenous origin, just like most of the legal provisions in Thailand and everywhere else. Same for that particular phrase. If we do the archaeology of that and the history of that particular sentence in the Constitution, well, it was added progressively. And the first one did not refer in 1932 to that phrasing, but in December 1932, so the second constitution of Thailand added the first sentence, and that first sentence was a copy and paste from the Japanese constitution. And then you had the addition of the second phrase. So once again, this was also very much a construct, a bricolage taken from here and there that was made a posteriori by the Constitutional Court into something very, very much the core of the identity of Thailand. Now, if we look at the actual ruling, and it was done a little bit before, so I will focus on what was not said. Well, if we look at the rulings, the court refers to a few precedents. In particular, it refers to the 2012 ruling, the one in which it established that lèse-majesté was part of DKHS. It also referred to the Constitutional Court decision in 2019 when it dissolved the Thai Raksa Chat Party for an attempt to overthrow the democracy with the king as head of state. So this is the ruling we will perhaps look into a little bit more than the others. The number 3 and 4 are the ones related to the dissolution of the Future Forward Party. So if you remember, there was before February 2020, when the court ruled the dissolution of the Future Forward Party, for a case not related to lèse-majesté, there had been another case brought against the Future Forward Party based on lèse-majesté. That was the one in February, 7 days before, and the Constitutional Court ruled not to dissolve the party, the Future Forward Party, on the basis of lèse-majesté. But still, that ruling is quoted in the decision by the respondents. Obviously, we understand why. And then there's another one, the one in 2021, referring to the protest by the youth against lèse-majesté that was then referred to by the petitioners. So the monk, ultra-royalist monk who actually petitioned the court. So perhaps it's been done before, but just very quickly on that very foundational 2012 decision. So this was a case that was part of, so the lèse-majesté law was challenged as being unconstitutional as part of a criminal case against Somyot Proksak Kasemsuk, which you might remember. So then the Constitutional Court replied that this lèse-majesté law actually gives to Article 8, which is Article 6 now, it was mentioned, its true legal force, right? And then in that ruling, it referred to that definition of democracy being part of that Western idea of constitutional monarchy that we take from the British, and also the Buddhist notions of kingship. So the court very much dealt further into that idea of Buddhist kingship, and this is how the Constitutional Court justified linking lèse-majesté with democracy, with the king as head of state. So it mentioned that the Thai monarchy is the heart and inviolable soul of Thai people, and that the king has reigned in accordance with the 10 principles of royal virtue, which is a Totsapit Prachatham, which is one of the basic principles of Buddhist kingship. So that's how that doctrine, mixing elements from here, was elaborated by the Constitutional Court. Now, I don't have time to go into the doctrine, but it was prepared by constitutional lawyers. Okay, now the Thai Raksachat court ruling, which is a dissolution case, which is a very interesting case because it was actually a different argument. What happened? The facts, perhaps you remember, we were in 2019, it was the first election after the military coup of 2014, and we had that side party affiliated with the Pheu Thai party, which was set up to present the sister of the king as candidate for prime ministership. Now, when this was announced, this was registered with the Election Commission, and then the king issued a statement, which you have reproduced here. So if we look into details here, what does the king says? He says, well, this action violates customs and conventions. So there are conventions to democracy with the king as head of state. So this is the idea that there are non-written rules that are attached to that doctrine. And these non-written rules are related to Buddhist ideas of kingship, among others, right? And so he says that the provision this constitutional provision extend to the queen and the regent, which then links to the sister. And so we see in that he uses this idea of militant democracy, that the court, or there is a need to prevent that political party from actually fielding that candidate based on this idea that this is amounting to overthrowing the democracy with the king as head of state. And he refers in this, well, I haven't highlighted it here, but he refers to this telegram from Prachatipak saying that the monarchy must be above politics. And this is also, there is a play on words with above politics, but we don't have time. In any case, this is also referred to in the ruling we had to read for today, that telegram from Prachatipak. And so the court ruled that Thai Raksachat had to be dissolved, and that this was because a democracy with the king as head of state implies that the monarchy must be above politics. And this is the Thai constitutional identity of Thailand, and there are constitutional conventions attached to it. And this refer back to Buddhist kingship. So the king is Dharma and it's above the constitution. Right, and this is exactly the same construction that we see again at work in the ruling that we had to read for today. Same in 2020, 2021, and now. So just a few thoughts. Well, the Constitutional Court is ruling in the name of the king. I have made the argument earlier that the Constitutional Court has that role to be a substitute king. And this is actually that role, that mission that it has taken onto itself. And we've seen that quite a few times in the past. And I'll be happy to answer to any of your questions. Thank you very much.
Thank you so much. Let me now hand the screen to Tamara Loos, who is professor and chair of the Department of History at Cornell University.
Thank you, Tyrell, and thanks for inviting me. I'm honored to be here. And it was really helpful to actually hear people who know the law so well explain kind of the construction of this court ruling and its history. And I have some questions for us all about what indigenization really means and who who gets to decide what really is indigenous. The kinds of things that I want to talk about are less explicitly about the law itself and more about some of the principles inside and outside the law and questions about language itself. So I reviewed Orwell's Politics in the English Language for this. And in that essay, he condemns language about politics that intends to hide the truth rather than express it. And I think there's no clearer example of this disturbingly Orwellian language than in the court case. So there's a couple levels of contradiction that I think have sort of been behind the scenes in both the first presentations, but I'll just pull them out. The first contradiction exists in the language of the ruling, which is kind of internally contradictory. It says, no person shall exercise the rights or liberties to overthrow the democratic regime of government with the king as head of state. And as Eugénie just mentioned, what is a democratic regime with the king as head of state? How can the king be simultaneously above politics, inviolable, sacred, but also at the center of it? That only works if the government is closer to an absolute monarchy than a constitutional one. Also, contemporary use of terms like exercise the rights or liberties infers an acknowledgement that people do actually have the legal right to overthrow the regime, but the law itself forbids them from exercising that right. Another kind of Orwellian twist that I see is that the ruling declares the royal institution is a pillar of national security, rendering any request to reform that institution the equivalent of government overthrow. And in this way, obviously, you guys already have pointed this out, Tyrell did, that peaceful requests to just consider reforming the laws protecting the monarchy from critique are considered the legal equivalent of violent revolution. The ruling collapses the space between those two very distinct acts. And I think it suggests a fear exists among those supporting the monarchy that this so-called pillar of national security is experiencing its weakest moment, since it requires so much legal scaffolding to protect it. And it begs the question, how can the royal institution be a pillar of national security when it needs laws to protect it from its own people? And when those who question the role of the monarchy are routinely jailed, they flee into exile, and they're even forcibly abducted, disappeared, and murdered for peacefully questioning and protesting. So something is out of sync or out of phase. The linguistic gymnastics of the Constitutional Court reveal a disjuncture, a disconnect, a misalignment between the political elite and society. And this ruling, what I want to draw some attention to is the timing of this ruling and what's actually going on outside of the ruling. The ruling comes in early 2024, at the same moment that Thailand's lower house of parliament almost unanimously passed a Marriage Equality Act allowing same-sex couples to legally marry. And I know there's some flaws in it. I'm not going to talk about those. Thailand also passed a Gender Equality Act in 2015 that protects people from gender-based discrimination. Again, I know there's some flaws in that, but still it was passed. And Thailand is globally known for gender reassignment surgery, and many individuals flock to Thailand for this procedure. So to me, it just raises this contradiction or this question about how can a regime be so politically repressive, but socially relatively open to LGBTQI issues. So it seems like there are these seemingly opposing forces coexisting. And usually those two things are in sync. So I was looking around and having conversations with some of my faculty who work on other countries, and it made me start considering other countries that are ruled by strong monarchies. So either absolute monarchies or constitutional monarchies that in fact exercise considerable political power. And those include Oman, Jordan, Saudi Arabia, Kuwait, Qatar, the UAE, Morocco, and Brunei. Morocco, Jordan, and Thailand are all constitutional monarchies, but their monarchs retain substantial power, unlike constitutional monarchs in Japan or Europe and other places that Akarachai mentioned. Of all of these monarchies that have substantive power, political power, Thailand is unique in its relatively progressive social norms and even legal rights given to non-normative sexual and gender identities. And so what's different about Thailand compared to these other countries with strong monarchies is obviously religion. Buddhism is not the state religion in Thailand, but it's practiced, of course, by the majority of people. You all know that. Whereas Islam is, in fact, the state religion in the other countries I mentioned. And so all sexualities outside of marriage, not just same-sex sexuality, are pretty heavily penalized in those places. LGBTQI is not singled out as something unique. So a little caveat, my purpose is not to denigrate Islam. It's interpreted in multiple ways around the world. It's not to laud Buddhism. Not all Buddhist countries or Christian countries approve of same-sex sexuality. For example, some forms of same-sex sexuality are illegal in Myanmar, which is a declared Buddhist country, and also these behaviors are prosecuted variously in other Christian countries. What I'm trying to do is draw attention to this strange anomaly or disparity in Thailand, where we see a repressive set of laws protecting the monarchy and severely penalizing those who peacefully ask about reforming lèse-majesté laws on the one hand, and at the same time pass laws that protect same-sex marriage on the other hand. So how do we explain this? It's clear that a great disparity exists between the social and the political. And maybe I'm oversimplifying that. I would love to hear other people's answers. But politically, Thailand is more repressive now, arguably, than it's been since 1932. You've witnessed a return to absolutism in all but name. More brave Thai citizens peacefully dare to question the role of the monarchy and the military, and more people are being penalized to the fullest extent of the law and the Constitution. But socially, law and the population are arguably more in sync, shown by the fact that the lower house, which is elected, has nearly unanimously passed the Same-Sex Marriage Act. So I bring up this comparison because, same-sex marriage law is just one concrete arena and maybe a hopeful arena that can explain the strange contradiction. If senators could be elected rather than appointed, we would likely see a different set of parties in power, as we did in 2023. The edifice, the scaffolding supporting the military or quasi-military governments and the monarchy is necessary because it's not otherwise supported by citizens. And I think that the support for same-sex marriage is one arena that reveals this profound disconnect between Thailand's leadership and its population. And so when I think about this ruling that we read for today and other things going on socially, I'm sure there are many other examples we could bring up. It's such a conundrum. It's such a strange disparity that I don't really see anywhere else in the world. And that's the kind of issue that I think bears paying attention to. Thanks. Tyrell, you're muted.
You're muted, yeah.
Thank you. Thank you so much. Let me now hand the screen to our final speaker, Ajahn Thongchai Winichakul, who is Emeritus Professor of History at UW-Madison.
Thank you. It is strange that you start with two people who know law and a legal profession, and ending with two historians who are ignorant about law. Anyway, my point would be, I'm glad that Eugénie talked before me because I cannot elaborate too much details, but my point would go along with her very well. To put it this way, after the ruling, political observers and legal experts voice out their concern that the ruling is full of sloppy reasoning, and worse, the ruling transgress or violate so many legal principles. Although most of observers, political or legal observers, they're not surprised by the ruling. They're not surprised. Usually people explain the lack of surprise in the sense that because the political situation make it predictable. But I would say that looking at, as Eugénie has shown so many past rulings, the Constitution Court, by the way, I often call it abbreviation Constitutional Court, to me is a Concord, not by intention, not by pun, but I like that. The Concord's ruling in the past was consistent with the latest one with the Move Forward Party. So my starting point of thinking about this is the sloppiness and transgression with legal principles. Whose or which legal principle? Whose or which jurisprudence? After observing several rulings, recent opinions by the Concord, I think the latest one against the MFP was not to serve short-term politics. Of course, that's a kind of, instead as a main objective, I think that to serve the short-term politics is consistent and with another objective, which is to establish a kind of Thai, Eugénie's word is a Thai legal jurisprudence with Thai characters. I would go along, I agree with that. And again, my approach is not, I understand the argument by human rights legal people, and I support the fight for freedom, support the view that Akarachai presented here. But on the other hand, as I pay more attention to legal history in the past few years, and I reach similar conclusion, of course, with much less, how to say, Eugénie's presentation is forceful. I cannot do that, but I reach a similar conclusion that the sloppiness, lack of principle that many people have voiced, there are opinions that judge, we judge by normative legal principle and the rule of law. But what if the Thai jurisprudence, what if the Thai legal principle does not follow the normative principle and rule of law, but has its own jurisprudence, has its own legal system based on its own kind of rule by law or rule of law? For example, Akarachai said, 112, according to the court, 112 is compatible with the right. The king is sacred. Akarachai pointed that the treason, the meaning of treason by the Concord ruling seems to be different from normative law. I agree. But if according to Thai jurisprudence, they have their own principle, they have their own reasoning, all of those may be understandable. Eugénie make it clearer by bringing the Buddhist notion of kingship. I reach the same conclusion. If we understand legal history, if we understand the first so-called foundation or modernization of the modern legal system in the late 19th century to the early decades of the 20th century, including especially the first criminal penal code in 1908, those are, I would say, practically the real constitution, especially the section on internal security, section on the monarchy. It has not been changed much. It was revised only twice, only minor points. Otherwise, that section remained virtually or practically the same since 1908. Keep in mind, 1908, the law was modernized, or the modern court system was created under the absolute monarchy. Now, when I say my point is similar to Eugénie, because Thailand has its own legal principle, has its own jurisprudence. The ruling of Concord, this time against MFP, is another moment to try to formally establish a royalist jurisprudence and royalist rule by law. I call it rule by legal exceptions. The acronym is RBLE, RUBBLE. I'm going to explain very short, succinctly in a moment. But I would like to point out that we often make opinion by contrasting the ruling with the normative rule of law. Then we find it sloppy, we find it violation or transgress the normative legal principles. Now, if we understand Thai jurisprudence better, doesn't mean I support it, but we understand what they try to do, then we will find that the ruling are mostly consistent with that. I think Eugénie has shown clearly already. The royalist jurisprudence, or the royalist rule by legal exception, royalist RUBBLE, is the dominant one in Thailand today. How it works, in my view, as I see from the legal history point of view, in regard to the realm of state and people relations, the royalist jurisprudence and the RUBBLE, rule by legal exception, apply. State and people relation, including monarchy and people relation, the RUBBLE and royalist jurisprudence apply. On the matters, on the cases of people relations, they try to follow the normative rule of law. You may say that there are two legal systems in the same legal system. That's correct. And this is not unusual. Thailand is not the only country which tried to do this. I give you a better version comparatively, but I call it a better version. If I have time, I explain why it's better. Look at Singapore. When it comes to national security, certain rules, certain principles apply. Otherwise, beyond that, it's first-rate rule of law, first-rate normative rule of law, much better than many other places in the world. But when it comes to the certain areas of state and people relation, such as the law that cover the press, cover freedom of expression, the law that cover public space, the law that cover associations, those is a state and people relations, a different set of legal principles apply. And it's better because it's predictable, it's in the book. The Thailand case is that kind of bifurcation, state and people relations is one thing, but people relations is another thing. It's worse because it's not quite clear and it's being formulated in action. Part of it is formulated and tried to establish by the Constitution Court, including the ruling against MFP. And this might be the answer to Tamara's Tamara's suggestion about this anomaly. I don't think it's an anomaly. If we understand that the sexual ruling about the gender and sexual relation, it's a people-people relations. It's not the state and people in Thai Buddhist political idea. In the Buddhist political idea, this is outside the realm of people and state relation. So the set of legal principles that apply for like rubble, the exception doesn't apply to those issues. Rubble give legal privilege to the state. Rule by legal exception give privilege to the state, serving the upper echelon of the power hierarchy. The legal privilege come in the form of emergency powers and exception of the due process, exception of the normal criminal procedures. And the ultimate privilege is impunity. Rights, the thing we call in English as right, is not inherent. People get those rights in court because I don't know what the word it is, because right in English itself is inherent, but I'd like to say that something called right in Thailand is not inherent. People get those rights as much as state grant to us. This is contrary to the most important principle of the rule of law. This alone tells us that Thai jurisprudence is not the same as jurisprudence as a normative one. The rubber works on the way the rubber works is they try to normalize the exception. They try to normalize the legal privilege to the state. They try to normalize the exception of due process when it comes to the state and people principle. Normalize the exception, including denial of bail. It's not right. It's not right because state and people in that case, it's about security, state and people relations. Then a different set of rules apply, including denial of bail, including assume that they are guilty, and it's assumed that it's a burden of the accused to try to prove that they are innocent. This all reverse. This all go back to the traditional legal practice. I would say that the modern state of exception in the Thai case, which become not exception, but become a normal part of the rubble or the Thai jurisprudence, they apply so many traditional practices into the cases involve state and relation and people relations. So we can see the normalization of those exceptions not only in emergency law or martial law like in many other countries, but in the normal laws as well, and guaranteed by guaranteed by the Constitution. The best Constitution, as people often say, such as 1997, if you look at the section on the freedom that people praise a lot, that is a Constitution that put 25 sections about jurisprudence, 25 sections about freedom. 20 out of 25 sections in that part about freedom. 20 out of 25 stipulate what are exceptions. And the state work or operate on those exceptions to the normal constitution right. That's why they can exercise emergency power, exercise the suspension of normal criminal procedures in cases that involve state and people relation. If I look at section 6, the king can do no wrong. Look at section 2555 that Eugénie raised above. If we try to understand Thai jurisprudence, we can see that those sections do not violate principle of Thai jurisprudence, which is different. Now, of course, We have to fight. We have to break. I think we try to realize, we try to understand the Thai jurisprudence, not to support, not to endorse, not to agree, not to follow it because it's Thai constitution, because it's Thai jurisprudence. No, but we need to try to understand this at least. Now, is it the return of absolute monarchy that Tamara suggests? Essentially, I believe so. Essentially, I believe it's not absolute monarchy between 1932. It's different kind. Sometimes some people call semi-absolute, semi-absolutist, whatever. But let's say it to some extent, it's a new situation with legal principle and legal and jurisprudence to serve such a kind of system. DKHS, democratic with the king as the head of the state, nowadays has turned into a form of semi-absolutist. And the legal principle, legal system, and jurisprudence, as we talk about today, is to serve such an absolutist or semi-absolutist state. 112 is a form of blasphemy law, like many other religious states, because it's based on fundamentalist, extreme radical fundamentalist Buddhist idea, which doesn't always interpret it this way, but in the past 20 years or so, it becomes the basis for interpretation of for jurisprudence and for exercise of legal power in this way. That's all I have to say. Thank you very much.
Thank you so much. So we have about 24 minutes for Q&A, and there's already 2 questions that have been raised. So while other folks are formulating their questions and putting them in the Q&A, we can start with these. From Sarah Bishop, she asks, Tamara, I have a question related to your comments on the disconnect between political repression and some more socially progressive policies. Something I think about here is the possible relevance of work by Rosalind Dixon on the idea of rights as bribes or perhaps as distractions. I note in this respect too that the time correlation of politically controversial and somewhat socially progressive policy is not new. Another clear example was 2012 with constitutional amendment decisions and decisions on rights of women and those who are disabled being issued by the court in quite quick succession. What are your thoughts on this as possibly part of the explanation for the timing and for the alternate directions?
Thank you, Sarah. I don't know the book. I'll definitely check it out, but I guess what I'm thinking about is that perhaps what we're witnessing is a polarization. It's hard for me to not think about the United States. And so these 2 opposing forces often do exist at the same time. I mean, it's maybe even more often than not. So and so I think that it's not the first time for sure. But thank you for drawing my attention to the 2012 laws. I'll have to take a look at those. I kind of want to say one other thing after listening to Thongchai and the other speakers, that part of what I feel like goes on when we talk about Thai law as somehow radically unique is we're once again we're othering Thai law, and part of what's important about this conversation and all the translation work that you do, Tyrell, is that we bring Thai law into a conversation with normative law, and we do point out the differences, but it's I don't want to keep it separate. I want to keep critiquing it for what it is actually doing, the kind of work it's doing in the world. I love this idea of it being blasphemous, 112 being blasphemous. The one comment that Thongchai made about people relations and sexuality, I think Buddhism can go some way in explaining these distinctions for sure, but what I find myself thinking about a lot, and also because I have students who work on this who are fantastic, is that many of the people who are activists right now are female. Many are queer, even if they're not all out. And for them, gender is a state issue because the state does dictate how girls at school dress, how boys at school, what toilet to use, all of this stuff. I do think it's a political issue. It might be a relatively new one in the case of Thailand, but I think it's going to become increasingly a political state citizen kind of issue. And I like to pay attention to that. So Sarah, sorry, I used you as an excuse to answer other questions, but thanks.
Thank you so much. Another question from Sarah Bishop, this one for Akarachai and Eugénie. She asks, in your presentations, you have drawn connections between pre-2014 and post-2014 decisions on the place of the king. I think those connections make a lot of sense. I wonder, however, have you seen any significant shifts in the language, for example, any intensification, or has the language, in your opinion, remained quite consistent? So whichever of you would like to start us off would be great.
Yeah, okay, why not? Thank you very much. Well, in my opinion, it's quite consistent, but more professional. So I think there is a more and more sophisticated way to draft rulings, and that these rulings borrow more and more into the repertoire of global constitutional scholarship. So looking at, for instance, the 2012 ruling, it's very poorly written in terms of how it mobilizes arguments from talking about the heart and soul of the monarchy being the heart and soul of the Thai nation, and the king having been working so tirelessly and so on. So this is the kind of ordinary writing that we do not, or less and less, find in nowadays rulings, which have a much more legalistic way of putting things, talking about constitutional conventions, about doctrine, about customs, about the type of items that we find in global constitutional rulings. So that would be my answer, and I would like to also add on to other questions, but perhaps let Akarachai answer first.
So I just want to add on to that a bit. So I can't comment very much on the difference in terms of the language between 2014 and after 2014. But what I want to note is that at least in the past few years, it seems that the way in which 112 has been applied and interpreted, I would say has been more problematic and intense. And I think there's a lot more legalistic angle to the way it has been applied and interpreted. A good example would be the case, a children's case, where a 16 or 17-year-old, the age I don't remember, was convicted under the Lethbridge's law for giving speeches in Bangkok. And in that case, to interpret the meaning of Article 112, the court looked to a royal announcement, a royal command, and saying that that royal command, not countersigned by any minister or parliamentarian, that royal command has a status equivalent to that of an act of parliament. And because that royal command having the status of an act of parliament, therefore it must be taken into account when interpreting 112. In fact, the court said that Section 6, on which the royal command was commenting, is the source, or Tontan is the source of Article 112. And because in the royal command, the king interpreted Section 6 to include not only the king, but the institution of the monarchy, Article 112 therefore does not protect only the king, the queen, the heir apparent, the regent, but also the institution of the monarchy. So in that ruling, it's quite problematic to see the court, the judiciary, equating a royal command to an act of parliament for the purpose of, in this case, legal application and the interpretation of Article 112. I think that's one of the most problematic rulings I've seen in the past few years.
Thank you so much. And I just want to note that thank you so far to everybody who has put their really fabulous questions in the Q&A box. I just want to sort of forecast that I know we won't get to all of them, so I apologize in advance. I want to turn to the question from Suli Wee from the New York Times, who asks all of the panelists to comment on what they think the significance of Move Forward being disbanded will be and what you think comes next. It appears that Move Forward has prepared a new party, but are we just going to see a Move Forward 2.0 or a Future Forward 3.0? Who would like to begin? No one.
I'm not a political, I haven't been following that as much, but it does seem like we've seen this with Thaksin's party. I mean, there's just future iterations, and I don't have anything particularly insightful to say about that, except that it's telling that new parties keep arising to push forward some of these things. Somebody mentioned in one of the questions that, and I remember this from the elections, that Move Forward was really pushed by their constituents to include reforming the lèse-majesté laws as part of their platform, that it might not have come, they might not have dared to do it otherwise, but they needed the votes. And so I think that is really important to point out. So thank the audience member who brought that up. But I would love to hear from Ajahn Thongchai or the others, what they would say in response to this question.
I think there are many other better, keener political gurus out there to answer these questions. I don't think I'm one of them anymore. If very brief, people often say that the new party would be bigger, not bigger, more successful. I just put a little doubt on that. No, it depends. So many other factors and so many, a few more years to come. So don't make that prediction. And I don't think about the conservative establishment as a stupid people. No, they know the lesson too, that the Move Forward party has been more successful than the Future Forward. So such as they might do something, they might do many things after the dissolution. We don't know. So let's say the Move Forward party have been saying that they are prepared for whatever coming. So let's see the whole situation unfold. I don't think I can offer anything better than those political gurus. Now, plenty of them are in Thailand now.
What I would say is that indeed, after the dissolution in 2020, it was widely believed that this was a one-shot, but actually it proved everyone wrong in 2023. So I think we're not, we can witness that again, since it's very, very much generational. The new generation, well, it's hard to put it, but there is the old generation who is dying, and part of the military now is very old. And if you look at how Thai voters have responded to political parties forming alliances with the military in the past, if you look at the trajectory of the Democrat Party, after it allied itself with the military, then it lost everything. I think it did 32 seats in the last elections, which is, for the oldest party in Thailand, is a death sentence. So I think it might very well happen to the Pheu Thai party, which leaves us with only one opposition, which would be the successor to the Future Forward party. And then perhaps a new party will appear, which will challenge on the, I wouldn't say on the left, but who would challenge on the, let's say, on the anti-military platform, the Future Forward. That's also a possibility that we can perhaps envision for the future. So
I think on my part, very quickly, I just want to echo Ajahn Thongchai's point that while there are many reasons to be hopeful, it is important to be quite cautious as well. For instance, and I just want to speak about our assessment last year after the election, and with the intervention into the electoral outcome by the military appointed Senate and other establishment forces, for instance, I think a lot of people understandably expected a lot of protesters, people to take to the streets, to protest, to express their opposition to what was happening to the electoral outcome. But I don't think the number of people that turn up was significantly high. And from our experience, it seems that a lot of people in the movement are tired. It's been several years since 2020. Many of them were in university, some of them are graduating, some of them are still subjected to quite restrictive bail conditions. And if you have to go through that several years, I think at some point, people are bound to get tired. And I think there's a risk that we might be at that point, that a lot of people are tired. And for instance, if the party were to be dissolved later this year, I'm a bit cautious as well as to what the public response to that potential dissolution may be.
Thank you so much. I want to go to a question from Abhinop Atipi Bunsin, who asks both Ajahn Thongchai and Eugénie of whether the royalist jurisprudence and its normalization as part of the Thai legal system has been in place even before the 1997 constitution through the operation of the Thai criminal courts and the Supreme Court of Thailand. If so, is it possible that the Thai Constitutional Court just automatically borrowed and applied the jurisprudence that has already been established without even thinking strategically about building a new line of jurisprudence? So in a sense, is this more of the same, or is it something radically new? And if so, with what implication?
My answer would be this. Looking at legal history, this kind of thing is up and down, not in the short term. I said already that the fundamental of royalist jurisprudence was, in fact, the foundation of modern Thai legal system. By the way, little footnote, I know that my English has been not as good because I haven't talked English at all for days. So forgive me about that. I try again. The foundation of modern legal system was created by absolute monarchy rule. That foundation has been laid dormant or laid that. It's a foundation all the time. Whether or not it has been reactivated or become more present or less present depends on political situation too. Because in the end, the rule of law or royalist rule by legal acceptance, whatever system, is not settled, fixed in place yet. For a long time, this kind of dominant royalist rule of law is not new, it's there. But with political situation, for example, to the other opposite, become more liberal, become more democratic. The interpretation and the exercise and application of this royalist rule of law would become less, or at least less pleasant. But in the past 20 years or so, the coup, and in fact, the situation before the coup, and I can trace back to the late 1990s, when the royalist dominance, Thai politics is dominated by the royalism, even though apparently it seems to be democratic, but in fact, among the establishment, the palace has been the dominant force. But it was the dominant force at the time when there was no resistance, there was no danger. So they don't need to exercise this royalist rule of law. But when it was in trouble, when the royalist dominance was at least challenged by whatever forces, maybe including Pheu Thai, or including I call it democratic or elected authority, it was challenged. Then they reactivate. And about the same time, this kind of royalist principle, royalist, how to say, in academic world, it also took time for them to elaborate, to formulate this kind of royalist jurisprudence clearly. It started in the mid-80s, not out of the blue, no, based on the foundation in history, but become more formal, written presentation of ideas such as by Chaimaneekarakate and Bhawan Sakuvano, this kind of a few other people. This start in seriousness in the mid-80s until it has become the kind of principle that the many courts can refer to. So my brief answer to this question is, yes, it has been there, but it doesn't mean that it has been there in the same way, in the same extent as it has been in the past 20 years. The past 20-year political situation escalate or exacerbate the presence of the royalist rule of law and that's why I say that ruling against MFP is a critical moment to try to establish the royalist rule of law, establish the bifurcation more clearly.
Yes, so I echo what Ajahn Thongchai just said. The Supreme Court, well, it all started with very royalist lawyers. We can go even further. We can go back to Seni Pramod, for instance, who's one of the very architect of this royalist idea of the rule of law. And this is in the late 40s. And then you have the Supreme Court taking on the doctrine of revolutionary legality, whereby courts are military coup are valid according to the law, and that's in the 50s. So yeah, the Constitutional Court has taken on those previously held doctrines by the jurist and by the court, but it has also built its own with constitutional law principles, the ones I referred to, in particular militant democracy and Thai constitutional identity. And also it's improvising a lot. It's a lot of bricolage, improvisation, and trial and error. But is it strategic? Yes, I think the Constitutional Court of Thailand is a very strategic court, just like any other court. And that ties back to the question about the rulings on LGBT. I think, yes, this is very often that we see courts handing down a very progressive ruling on a non-political issue like same-sex marriage or maybe family name for women. The Constitutional Court also did that just before handing down another ruling that is very repressive. And that's part of a wider, let's say, political economy of authoritarian regimes to pinkwash themselves, or even now they do greenwashing with the environment. So Thailand has been doing that consistently since Sarit Thanarat, who started to, let's say, promote Thai women in the Miss Universe and so on, to show a soft-spoken face of Thailand. And we can think of so many other countries. I think about Israel, for instance, who's been using pinkwashing for a very long time. I think the term was even invented to refer to Israel. And I just want to make another point about Buddhist kingship, which is what Catherine Bowie just posted in the chat about that idea of Buddhist kingship. We don't know what it is. Yes, precisely. Each discourse is a political battlefield, and the Buddhist kingship is actually one of the discursive battlefield that is completely left out by the pro-democracy activists. So they've been using the pro-Western rhetoric and the rule of law and the UN principles. But my suggestion would be that perhaps it would also be wise for some pro-democracy activists to invest into that political battlefield about these Buddhist notions of kingship or about monarchy, in order to shift that meaning and to use that to weaponize the Buddhist notion of kingship for democracy. So that could be, I think, perhaps an idea that has not been taken on by activists in Thailand so far.
Tyrell, may I add a few more?
Of course.
I like to follow Eugenie's point. In the battles among legal concepts, among legal professions, they try to advocate for natural law. The royalist jurisprudence is a part of what they got. The result of the advocacy for national law, then they become conservative royalist rule of law, because the opposite of the national law is legal positivism. So I like many Thai lawyers today, including those human rights lawyers. They often say they are against legal positivism because they support national law, but they didn't look at the so-called national law is conservative national law, royalist national law. So that's another angle that you should, the legal people, legal profession should ask themselves about the concept they learn too. This may not be applicable or may be hard to understand for the legal profession outside, but this is quite institutionalized into the concept among Thai legal professions. Another thing I'd like to mention that the question Tamara asked earlier, the sexuality become the state matter. I agree. When I say state people and people, partly is my problem of English. I don't know. My idea is still trying to formulate the distinction of this sphere. All I can say is this. Even in Singapore, it doesn't mean everything about the state has to be under the special kind of security issue. In Singapore, they identify 4 or 5 or 6 areas. This area by certain laws should follow such and such principle, different from other laws. So in Thailand, I would say sexuality is among many other things that the state do not care or do not apply the exceptions. Let's say for murder is a criminal violation, killing people. They would let that, killing people among people themselves, Mr. A killing Mr. B, then let the due process work it out. The state would not apply legal exception, but for national security, for monarchy, they would apply legal exceptions. I use the word state and people versus people, that might not be right, but help me out. Sometimes we need to try to understand better what areas the state care to apply legal exceptions, to apply Thai jurisprudence, what area, even though it theoretically is under the purview of the state too, such as criminal violation among people themselves or sexuality. I would say the Thai state would let that they do not apply legal exception in those areas. That's all I say.
Thank you so much. We are out of time, but I want to give the last word to Akarachai and ask him to answer or offer a comment to the question raised by Eric White, which is, given the current political and legal situation, what do you see as the most promising avenues forward for legal change and reform, either in the near or immediate future, or intermediate future?
So I think I would take this opportunity to speak about one of our campaigns, which we hope will be successful. We are still pushing really hard. We know the chance is pretty slim, and that's the amnesty campaign. As I was saying, since 2020 alone, almost 2,000 people, including no fewer than 280 children under the age of 18, have been charged in the various laws, some sentenced to really long prison term. If the government insists on wanting to prosecute every single case to its very end, we would still be here in 2025, 2026. So we think one of the best ways out for them, especially now that Thailand is running for a seat on the UN Human Rights Council, I think one of the best ways out for them is to grant amnesty to people who peacefully exercise their right to freedom of expression. Another avenue that I want to talk about very quickly would be Senate election. Current justices on the Constitutional Court are there on the Constitutional Court with the approval of the military appointed Senate. And the next batch of Constitutional Court justices will be there again with the approval of the new batch of senators. So what happens later this year in terms of who will be populating the Senate will matter a lot in terms of the sort of jurisprudence we will see from the Constitutional Court too. And that's why our friends, especially at iLaw, for instance, are pushing really hard for people to run for Senate, a seat on the Senate, so that they will be able to make changes through that avenue.
Thank you so much. I just want to conclude by thanking these 4 fantastic panelists for their really thought-provoking and challenging comments, and just end by saying, I think all of this discussion, all of the questions indicate that there is an urgent need to take the Constitutional Court and other judicial institutions in Thailand seriously, that this is, it needs a lot more attention from, I think, from lawyers, from historians, from activists, from all of us. So thank you so much. And for those who are starting your day, have a fantastic day. For those who are ending, have a good night. Thank you again.
Thank you.